But right now, very pleased to have with us on the program Warner Todd Houston with the Publius Forum. And Warner, good evening, sir.
How you doing? Thanks for having me on.
It's my pleasure. A great piece at ChicagoNow.com. Supreme Court Justice Breyer, the founders were for restricting guns, why Breyer is wrong. And thanks for joining us, by the way, on Bill of Rights Day. I can't think of a better day to talk about this issue.
Perfect day. You're exactly right.
So you saw Justice Stephen Breyer on Fox News Sunday insisting that the Bill of Rights and in particular the Second Amendment really didn't mean much to the Founding Fathers. It was sort of thrown in as you say, a sop to the states. I said earlier it was sort of like the colonial version of the NRA lobbied for the Second Amendment to be put in there. And Breyer says, because of that, it's easier, I guess, to disregard the Second Amendment today, right?
Well, one of the things he was trying to really focus on was the fact that Madison's real focal point was the militia, to limit a standing army, because the founders were afraid of a standing army because, after all, throughout history, standing armies led to tyranny. So
including the standing army that came in and ended up shutting down Boston.
Exactly. So they wanted to avoid that, having a standing army, and of course the whole militia idea was their solution to that. But Breyer was saying, well, see, that's all they were interested in. They weren't interested in individual rights and self-protection. They were only interested in the militia. Well, this was complete nonsense here.
Well, absolutely it was. And you say, first of all, it's a bit ridiculous to take any one founder's words and assume that it represents the opinion of all of them, particularly
right.
When you're talking about the Constitution and the Bill of Rights. You will find a wealth of opinion from the founders, from those who believed that the Bill of Rights would actually give the government more power, because anything not enumerated, the government would presume that it could take away from us, all the way to individuals who proposed amendments that never made it into our Bill of Rights that would have restricted federal government power. You're right. There's no one founding father philosophy on the Bill of Rights.
The fact that we have a Bill of Rights at all is an example that we can't use any one founder's ideas, because the original Constitution didn't have it. That was a compromise to go back later and fix. So that was. Some founders said that we didn't need a Bill of Rights,
Yeah, absolutely. And there were, as I understand it, 75 amendments that were originally proposed.
Right.
12 of them made it to the states. The states ratified 10 of them.
Correct.
What's interesting, I was going back and I was reading the Bill of Rights today, and in the preamble to the Bill of Rights, which nobody really reads anymore, you get a very clear idea of what this was all about. It reads, the conventions of a number of states having at the time of their adopting the Constitution expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. In other words, the Founding Fathers told us why the Bill of Rights was adopted, and that was because the people were concerned about an abuse of power, and they wanted to put further restrictions on the federal government. That's pretty clear,
exactly
right?
You would think it's pretty clear, but of course, then we have people like Breyer and the Living Constitution folks that want to, focus like a laser beam on individual words instead of the entire history of the era, that they must draw from to get an interpretation of that document. And they want to ignore all that. They just want to, become legalese. They want to make it legalese instead of a guiding document of our history.
Yeah, and you quote Breyer. He says it's a matter of what those framers intended, and you saw that first phrase. Well, regulate a militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. What does that mean? The militia. Historians told us, and the dissenters thought that they were right, that what that meant was that James Madison, thinking, I've got to get this document ratified, was worried about opponents who would think Congress would call up state militias and nationalize them. That can't happen, said Madison. The militia were the body of the people.
Exactly. I mean, if you look back at the rules of what the militia was, it was everybody. I mean, it was anybody that was able to hold a gun, anybody that was able to come together and form an army to protect the country. It was all of us. So to try to separate that, quote, militia away from the whole of the people is completely erroneous historically.
Well, absolutely. Justice Joseph Story, you quote the justice, who was a contemporary of Madison, said
Yes.
the right of the citizens to keep and bear arms has justly been considered as the palladium of the liberties of a republic, since it offers a strong moral check against the usurpation and arbitrary power of rulers, and will generally, even if these are successful in the first instance, enable the people, and again, you find that phrase, the people, to resist and triumph over them. So it was not about the militia per se. It was not about calling up the militia to by the federal government. This was about the right. Again, it's right there in the Bill of Rights, the right of the people to possess those arms. And this was not a new right either, Warner.
No, not at all. I make the point in the piece, in my piece here, that one of the leading jurists of the day was a man named William Blackstone. He was a man that wrote the biggest book about the English common law. Now, we have to also remember that the Americans here, the colonists, thought that they were being more true to the English common law than the actual English were. So they relied very heavily on the English common law. And William Blackstone, in his work, he went on to describe self-defense and how it's basically a natural right, a law of nature. It was an assumption that an individual citizen had the right to protect himself and have the arms to do that. And all the founders, pretty much, from what I've seen, agreed with this natural right. So it was something that they didn't have to put into the Constitution and further explain, because it was simply something that everyone assumed. For instance, as we assume that when someone talks about the sky, we're talking about something that's blue with white clouds. You don't, when you say, hey, the sky's nice today, you don't say, hey, the sky's nice and blue and got clouds, and you don't go into it because it's assumed it's a blue sky, right?
Right. No,
they assumed that each individual citizen had a natural right to self-protection, so they didn't have to go through the Constitution and back explain every single little notion that they based their ideas on.
No, you're right. The modern concept of gun control, which dates really back to the late 1960s, that wasn't found in the founders' philosophy. I mean, you can look at founders as different as John Adams and Thomas Jefferson, and you will find very different philosophies, but you'll also find both Jefferson and Adams supportive of the individual right to keep and to bear arms. Adams even talked about the need for state laws to regulate militias and to regulate arms, except those in the private hands of individuals. I mean, he carved out that exception for individual citizens owning their own private firearms. That's where he said, hands off.
Right. So I find that the one disconnect about gun control advocates, the most amusing, if you will, the fact that we based our entire country on the ability of the citizenry to revolt against England, and the gun control folks assume that the founders didn't mind, on the other hand, taking those guns away from their own citizens. I mean, that's a logical disconnect that makes no sense whatsoever. It would be completely hypocritical of the founders to start a country based on the idea that they could reject the government and then take that very right away from their own people when they start their own country.
Well, this is the attitude that is on display here, Warner, and as you say, it's an attitude born of this idea that the Constitution is, in your words, elastic and living, and you don't really need to amend the Constitution anymore. All you need to do is reinterpret the Constitution, which is a heck of a lot easier to find a judge that will agree with your interpretation than it is to amend the Constitution the way the Founding Fathers intended for us to do.
That would be true. And additionally, as we were saying, you can then ignore all of our history. You can ignore the founders' ideas. You can ignore the idea of natural rights. You can ignore everything that's happened previous and base all of your ideas of law on your current temporary ideas of what it means. It's very convenient.
It is. It's very convenient. It turns basically hundreds of years of common law on its head. But yeah, it's awfully convenient when you want to get your way. It's a great piece, Warner. Again, chicagonow.com and the Publius Forum. That's where folks can find this. We've tweeted a link as well. I can't thank you enough for coming on the program. I hope we can do it again very soon.